Florida. We are here today at the law offices of Demesmin in Denver. Of course, our trusted legal advisor, and joining us are none other than Cam and Hunter. Welcome back to ISF.
Hey, thanks for having us.
Good to see you.
Good to see you guys too. Well, we are talking about another great topic today, wills and trust demystified, all about your questions being answered. So our first question is talking all about, should you have a will if you don't have significant assets?
So I think it's incredibly important for anyone, no matter how many assets you may think you have or don't have, to go ahead and get a will or even potentially a trust set up to just protect kind of your interests after you're gone. I know in my family, my mother ended up passing away without a will, and it just it created a huge amount of problems that I know she wouldn't have wanted to have my sister and I and our family deal with. And just even creating a simple will, if you think that you have kind of not a significant amount of assets, it can make everything smoother and easier on your family so they can focus on the grieving process, frankly, and dealing with everything thereafter.
Yeah, most definitely. And thanks for sharing about your mother, too, and the great information as always. And Cam, going to you on this next one, can a will be contested after death, and what happens exactly if it is?
Well, yes, it can be. You have a will contest. Once you're served with the petition that wishes to admit the will into probate, you have 90 days to contest that will. What happens is the judge will hold an evidentiary hearing and hear testimony, hear from experts, fact witnesses, look at documents, medical reports and documentation and such, and determine if this will was actually fraudulent, if it was made with undue influence, under duress, if you forced or coerced someone to do it, and then make a determination whether the will should be admitted or whether it should not be admitted into court.
Well, I think it's pretty clear that a will is necessary. We should definitely have a will. And so, Hunter, how young is too young to create a will?
I think as soon as you're 18 years of age, is a fine time if you're working and you're out there and you have, assets that you'd like to be distributed in any kind of way. I mean, to a girlfriend or to make sure that they go to the right family members. Unfortunately, the unknown is the unknown, and you never know what could happen. So it's important to protect yourself.
That's right. And after you've created a will and after maybe it's even been signed, are you able to alter or change any of that? What's the process like?
Yes, and that's called a codicil, and it's basically just you modifying the terms of the will. It's an additional document, but it is normally kept with the attorney who prepared the will. And once that will is actually probated, then the codicil is probated with it.
Guys, great information as always. I always learn a lot whenever I come here to Demesmin in Dover. Where can we go for more information?
Well, you can go to youraccidentattorneys.com and check the Wills and Probate tab. And you can also give us a call at 866-954-MORE. That's 866-954-6673.
Guys, thanks so much for hopping on to ISF. Always a pleasure chatting with y'all.
Oh, the pleasure's all ours.
Absolutely.